Hi, I'm Darcel Lobo and I own Dow Law Firm in Normandy Park. And today's question is one that I talk about with my clients a lot, especially those who have minor children, which is at what age should you leave an inheritance to your child? So in Washington State, a minor, someone who's under the age of 18, is not competent to inherit anything. Okay, so we have to make sure we're at least planning for age 18. But I tell my clients at age 18, your child's probably not ready to receive an inheritance. And especially depending on what the extent of the inheritance may be, if it's real estate and financial investments, life insurance proceeds, investments. Like for most of my clients, they've worked so hard to acquire and to build their assets that leaving them to a child at the age of 18 is usually not the best idea. So what is the best idea? Well, it's going to be case by case. I don't have a rule for everyone that works in all cases, but I do have recommendations. So in Washington State, we have what's called a custodial account, where you can name someone as a custodian of those funds. So maybe it's, a sibling of yours, another trusted relative, or, a really close family friend, someone that you would entrust to really hold those assets. And I say hold in quotations because it's still going to be in an account at a bank for the benefit of the minor. But whoever you name as custodian is kind of in charge of those funds. For those custodial accounts, they have to be distributed by the age of 25. So that gives you some planning from ages 18 to 25 with a custodial account. If you want to plan beyond that, or some clients want to have more discretion as to when those funds can be used or how they can be used. Now, I tell my clients we can only control from the grave to a certain extent, right? At some point, we have to release the funds. So for some of my clients, we do the custodial accounts, and that's great. For some clients, they decide that they want the child to have the funds at the age 18, and that is entirely their choice. I talk to them about the pros and the cons, and but ultimately you make the decision, and as long as it's legal, which is for a minor over the age of 18, we can do it. But beyond that, sometimes we do like a trust for minors where we have more control of the funds. So a scenario for that would be like, giving the minor, half the funds at a certain age and the other half later, or breaking it into thirds. A really common one that my clients really like sometimes is breaking it into thirds at ages 25, 30, and then 35. So you're kind of giving the child multiple attempts to not blow their inheritance, right? At those ages in life, maybe they're having a child, maybe they're getting married, right? So they're at different points of their lives to where, hopefully they'll make some more responsible decisions with the inheritance when they receive those funds. Now, if we do that, we also have language in that trust for the minor that says, whoever your trustee is of that trust for the minor, they have the discretion to make distributions that are needed for the child's health and education and well-being, right? So if the kid is going to college or a trade school or has any kind of medical needs, that the funds can be accessed for those specific purposes, but there are no lump sums given to the child outright until they reach the ages that are specified. So some clients may already know at what age they want the child to receive those funds. But if you don't, we discuss kind of the various options. Again, the 25, 30, and 35 is a really kind of popular choice among my clients, especially if it may be a larger inheritance. But also using the custodian account and maybe giving a lump sum at age 22, right? Maybe at that point they finish college, or age 24 or 25, and not breaking it into halves or thirds or having additional strings attached to those funds. So, for each client, it's going to be case specific as to what is the best fit for them and for the child. But we had that discussion during the consultation, and I'm helping you to decide and kind of guiding you. I've seen a lot of things. I've seen estate plans when they don't go very well, right? When there's no estate plan, or that the minor wasn't provided for. So in doing a real thorough job of putting your estate plan together, really giving it, really good thought and thinking behind it as far as how it's going to play out and what that's going to look like. And I will just mention that sometimes I have clients where they have named the minor on a life insurance policy, on a retirement account, on a financial account. And a lot of these institutions will let you do so, and you can name a minor. But what happens if you pass and the minor is still a minor? The minor is not going to receive that lump sum outright. Because again, under Washington state law, they're not competent to inherit. So what happens? Well, we usually have to open a guardianship. So we have to go to court, open a guardianship account for the minor. The court appoints a guardian to oversee those funds and how the funds are distributed. There's all kinds of reports that have to be filed. There's really strict limitations as to what the funds, how they can be invested and how they can be used. And then they're given to the minor once the minor turns 18, they're released to the minor. That process of guardianship for, a minor's inheritance is really lengthy and it's really expensive. It's quite a process. And so with a little bit of estate planning, we can avoid that and maximize what's going to the minor, protect those funds for the minor, and have them used in a way that you deem best fit and not, a court that doesn't know your family or your child or, what's best in that scenario, right? They're doing the best they can, but they don't know your family, they don't know your child firsthand. Versus if you do an estate plan that provides for this, you can ensure that your assets are being protected to the extent possible, and also that they're going to be used in the minor's best interest and be distributed to the minor, in accordance to what you think is best for the minor, because you know that minor firsthand, right? Especially if it's your child or your grandchild, maybe a niece or a nephew. So you get to decide and put that in your estate plan. So if you need help with your estate plan, if you don't have an estate plan, but it's been on your to-do list for maybe a number of years now, that happens. I understand. It's not a conversation that a lot of my clients are just, jumping at the bit to have, right? But it's a necessary one. And having a really well thought out estate plan and something that's, very organized and put together for your family is one of the best gifts that you can leave them. So if you need help to get your estate plan together, if you have an estate plan, maybe it's a little outdated now, we need to make some updates, reach out to our office. Again, I'm only licensed in Washington state, so this is specific to Washington residents, and I'm only licensed in Washington, so I can only help Washington residents. So if you want help with your estate plan, give our office a text or a call at 206-408-8158, or visit us online at dallawfirm.com, DALLAWFIRM.com. But I'll have all that listed below for you, and I would be happy to help you. All right, have a good day.